Hello and welcome to Courts This Week on LiveLaw. I'm Taniya Pandey and every week I come to you with last week's top court updates. To continue learning about the latest judgments, subscribe to LiveLaw. We'll begin the episode with judgments from the Supreme Court and then move on to the High Courts and other courts. The Supreme Court has observed that the top court's interference is not required in policy decision when a state is in a position to point out that there is intelligible differentia in application of policy and that such intelligible differentia has a nexus with the object sought to be achieved. In this case, a single judge had allowed the appellant's writ petitions directing the state to grant bonus marks to the appellants who had worked under the National Health Mission and the National Rural Health Mission schemes in states other than the state of Rajasthan. The division bench of the High Court set aside the single bench decision. Challenging this, private parties approached the Supreme Court. Dismissing the appeals, the bench of Justices L.N. Rao and B.R. Gavai observed that courts would be slow in interfering in the policy matters unless the policy is found to be palpably discriminatory and arbitrary. The Supreme Court upheld a Rajasthan High Court judgment which held that Real Estate Regulatory Authority can entertain complaints by home buyers against the bank which took possession of a real estate project as a secured creditor. Before the Rajasthan High Court, the Union Bank of India and others had questioned the authority of RERA to issue any directions against a bank or financial institution which claims security interest over the properties which are subject matter of the agreement between the allottee and the developers. Referring to definitions of the terms like promoter, assignee, etc. in RERA and also the Sarfazi Act, the High Court had observed that the moment the bank takes recourse to any of the measures under subsection 4 of section 13, it triggers statutory assignment of right of the borrower in the secured creditor. The High Court also considered the issue of applicability of RERA while the Sarfazi Act is also activated. While hearing special leave petitions assailing a Gujarat High Court's demolition order, the Supreme Court directed the Surat Municipal Corporation to accept the forms given by the desirous applicants for grant of alternative accommodation in view of demolished residential house on the railway property without insisting on deposit of Rs 20,000 as a precondition. The bench of Justices A.M. Khanvilkar and C.T. Ravikumar, however, said that if authorities, after processing the form, found the applicants eligible for allotment of some residential accommodation, they may intimate the concerned person. The Supreme Court has observed that a quasi-judicial authority has a duty to disclose the material that has been relied upon at the stage of adjudication. Keeping a party bereft of the information that influenced the decision of an authority undertaking an adjudicatory function undermines the transparency of the judicial process, the bench of Justices D.Y. Chandrachud and Sanjeev Khanna observed. The court added that the authority's own statement that it has not relied on certain material would not exempt it of its liability to disclose such material if it is relevant to and has a nexus to the action that is taken by the authority. The Supreme Court has refused to grant relief to an aspirant who claimed admission to the PG course for academic year 2021-22 based on his rank in NEET PG 2019. The candidate's rank in 2019 was not considered due to a discrepancy in the surname in his caste certificate. The candidate claimed that his 2019 rank be considered for the 2021-2022 admissions. The bench of Justices L.N. Rao and B.R. Gavai, which was considering an SLP, assailing a Madhya Pradesh High Court's order dated March 4, 2020, said that he is certainly entitled to be treated as a scheduled caste candidate for 2021-22 admissions, but his 2019 rank cannot be considered. The Supreme Court has disallowed the claim for damages raised in lieu of specific performance of contract, citing the reason that the plaintiff had not specifically sought the relief of compensation in the plaint. The court referred to Section 21, subsection 5 of the Specific Relief Act, which says that no compensation shall be awarded under this section unless the plaintiff has claimed such compensation in his plaint. A bench of Justices L. Nageshwar Rao and B.R. Gavai was considering an appeal from the judgment of the Calcutta High Court. The issue related to contractual disputes between the appellant and the respondent. The issue as to whether pension seeking to make any distinction between categories based on a cut-off date is violative to Article 14 of the Constitution of India or not has been referred to a larger bench by the bench of Justices Sanjay Kishan Kaul and M.M. Sundaresh. The court was considering an SLP against a Himachal Pradesh High Court's order, wherein the High Court had declared the cut-off date of January 1, 2006 for payment of pension as per 6th Central Pay Commission as arbitrary. The bench expressed reservations regarding the dictum of a two-judge bench in All Manipur Pensioners Association case that the classification of pensioners into two categories by providing cut-off date for the purpose of grant of revised pension is unconstitutional. Let us now go over important judgments from the High Courts and other courts. The Allahabad High Court has observed that for adopting a child, a marriage certificate is not a sine qua non, and even a single parent can adopt a child under the Hindu Adoption and Maintenance Act 1956. The bench of Justices K.J. Thakkar and Vivek Verma made this observation while dealing with a plea filed by a transgender person and her husband who sought a direction upon the Sub-Registrar Hindu Marriage, District Varanasi, to consider and decide the online application for marriage filed by them. The Madras High Court has directed the National Medical Commission (NMC) to circulate the expert committee report and recommendations pertaining to conversion therapy among the state medical councils empowered under the NMC Act 2019 to take disciplinary action against professional misconduct. The court has instructed that NMC should complete the exercise within 4 weeks. Justice N. Anand Venkatesh gave the above direction in a protection plea filed by a lesbian couple facing police harassment and pursuant to a slew of guidelines issued by the High Court to ensure the protection of LGBTQIA+ persons in consensual relationships. A special court on 18th February sentenced 38 people to death in the 2008 Ahmedabad serial blast case. As many as 56 people were killed in the blast that rocked Gujarat's capital on July 26, 2008. The court sentenced 38 of the 49 convicts to death under provisions of the Unlawful Activities Prevention Act and Section 302 of the IPC. The 11 others were sentenced to life in jail till death. Justice A.R. Patel also awarded compensation of Rs 1 lakh each to those killed in the blasts and Rs 50,000 for each victim with serious injuries and Rs 25,000 each for those with minor ones. The Allahabad High Court on 16th February handed over probe to the CBI in an alleged scam of Rs 1,200 crores in the subsidy to the manufacturers of fertilizers without the actual supply of fertilizers by the manufacturers to the distributors. The bench of Justice Gautam Chaudhary passed the order in a Section 482 CRPC application filed by one of the accused in the scam who sought for quashing of the entire criminal proceedings in the case against him. The court ordered that a progress report with regard to the CBI investigation shall be placed before this court on March 21, 2022. A Delhi court has observed that expression of a victim's trauma or experience is his or her fundamental right, which can only be curtailed if it falls under 4 broad categories. Additional Civil Judge Preeti Pariva listed the 4 categories as libel, slander or defamation, contempt of court, that which offends decency or morality, and undermines the security or tends to overthrow the state. That's all for today. I appreciate you joining us. I am Taniya Pandey for LiveLaw and you're watching Courts This Week. Have a great day.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.